Hello everyone and welcome to this video tutorial on automatism. Automatism is also known as non-insane automatism, so it is closely related to the defense of insanity or insane automatism, which we looked at in a previous video tutorial. Automatism is an act done by the muscles without any control by the mind, and if successful, it is a complete defense to a crime. This defence is available for defendants whose actus reus is done involuntarily. The defence of non-insane automatism, or just automatism for short, is where a person commits a crime in circumstances where their actions can be said to be involuntary. This could be where, for example, an involuntary natural reaction occurs, such as sneezing or being chased by a swarm of bees. The defence, if successfully pleaded, acts as a complete defence, absolving the defendant of all criminal responsibility. Automatism differs from insane automatism or insanity in that there is no power to detain in a mental hospital, neither may any other order be made against the defendant who's acting out of automatism. The main difference between insanity and automatism is that insanity is caused by an internal factor or an internal cause, i.e. a disease of the mind, which we've seen previously just means any illness which affects the mind. Whereas what we're going to see with automatism is that automatism is where there is an external cause. So internal insanity, external automatism. For automatism to work, there are two requirements. Firstly, the actions of the defendant must be completely involuntary, and secondly, the cause of the automatism must be external. The first requirement for automatism is the actions of the defendant must be completely involuntary. And in the case of Bratty and the Attorney General for Northern Ireland, Lord Denning gave us a definition of what automatism might include. So Denning said, quote, that it is any act done by the muscles without any control by the mind, such as a spasm, a reflex action, or a convulsion, or an act done by a person who is not conscious of what he is doing, such as an act done while suffering from concussion or sleepwalking. I should just point out here, though, that the concussion or sleepwalking would have to be shown to have been caused by an external factor rather than an internal factor, because remember, requirement 2 for automatism is that there's an external cause. But if you think about what Denning's saying here, he's saying that automatism is where the muscles are doing something without control by the mind. So a classic example is shown here in this diagram. This is showing a reflex action. So where a doctor is hitting your knee in the right place here, your leg will automatically, without any control, kick up. And that is a reflex action. It's not done consciously by the person, and so that would raise the defence of automatism. The defence to work, there must be a complete loss of control. A reduction in control is not going to be enough for automatism. And this is shown in the case of AG's reference number 2. In this case, we had a lorry driver who crashed into some cars that were parked on the hard shoulder of a motorway, and 2 people were killed. Our defendant raised the defence of non-insane automatism based on the fact that he was driving without awareness, which is a recognised psychiatric condition, which was induced by repetitive visual stimulus. And this is quite an interesting thing, but apparently lorry drivers who travel a long way on the motorway, particularly at night, they go into almost like a hypnotised state, because the lights coming at them over and over again, it puts them into a sort of semi-hypnotised state. So he raised this as a defence to say, you know, I wasn't in control of my actions at the time, I should have automatism. But he was not allowed the defence, and the court held that the defence is not available where you've got reduced or impaired control. The Court of Appeal said, and this is a quote from them, there must be a total destruction of voluntary control. And although driving without awareness is a recognised condition, What they were saying there, psychiatrists said that he still maintained some control because he was still able to use the steering wheel, to use the brakes, still had a degree of control left. So for automatism, we want a complete loss of control. The second requirement for automatism is the cause must be external. Any involuntary action from an internal cause will be insane automatism or insanity. So we need to have an external cause. So some examples here: a blow to the head, attack by a swarm of bees, sneezing, the effect of a drug. These would all be external causes. Just added in here for you with the sneezing, the case of Woolley, because this is an example of a real case where sneezing was held to lead to the defence of automatism. And just so you're aware what happened here, the defendant was a lorry driver and he was travelling on the M62 in a queue of slow-moving traffic. He suffered a big sneezing fit and he lost control of his vehicle and he bumped into the car in front. This car in turn knocked into the driver in front of him, and it caused a domino effect involving 7 cars. And the magistrates in that case allowed the defence of automatism because the attack of sneezing could amount to an involuntary action for the purposes of non-insane automatism. Another case on external causes is R&T. And this was a case with really unpleasant facts. Our defendant in this case was actually gang raped, and it was a very traumatic event. And as a result of this incident, she suffered post-traumatic stress disorder. And whilst in a semi-conscious state, she committed a crime. And she was able to plead the defence of automatism. And the court held that exceptional stress can be an external factor that can cause automatism. So the courts were saying here that the rape, in essence, was an external factor which caused her to go into this automatic state. But you need to be careful here. It's going to have to be exceptional stress for automatism to apply. As we're talking about external factors and automatism, we need to go back and think about 2 cases that we've mentioned already when looking at the defence of insanity. And these are the cases that are to do with diabetes. Because as we already know, there's a bit of a daft distinction in the law between a diabetic state caused by an external injection and a diabetic state just caused from not taking an injection, i.e. it's the internal diabetes which is the cause. And this means that there's a difference between you being able to plead automatism or it being insanity. So if you recall, in the case of Quick, the defendant had hypoglycemia. Hypo means low blood sugar, and that was caused by an external factor because he'd taken his insulin, but then he'd not eaten and he'd drunk alcohol. So because it was external, he could have automatism. Whereas we always compare Quick to Hennessy, and in this case, he was hyperglycemic because of an internal factor, He hadn't taken his insulin, so it was his internal diabetes which was acting on him, and he therefore had to rely on the defence of insanity. So this is totally daft, and if you were doing an evaluation essay on insanity and automatism, this would be a big area to be critical on, that it seems really daft that if a diabetic state caused by external taking of insulin is a complete defence, automatism, whereas if you don't take your insulin and it's an internal cause, it's insanity, which in theory you could end up locked in a mental institution. This is clearly a very unsatisfactory state of affairs. And you can see, hopefully, from the case of Quick that another potential problem arises here. Because if we now know that if you are diabetic and you take your insulin, you might then have a complete defence to a crime. So in theory then, if you're diabetic and you want to kill your husband, just take your insulin and then kill him and you've got a complete defence. That is really problematic, obviously, for the law. So, to get around that, there's a rule that's been developed called self-induced automatism. And what the courts have done with self-induced automatism is that they say that if the defendant knowingly puts himself in a position of automatism, then the defence of non-insane automatism will fail. So where the external factor is alcohol or drugs, the defence of intoxication will apply, and therefore it's going to depend on whether the crime's one of basic or specific intent. So we've got a case to illustrate self-induced automatism here, and it is the case of Bailey. Bailey was a diabetic who failed to eat enough after taking insulin. So he'd taken his insulin, external cause, potentially automatisms available. He's become aggressive, hit the victim over the head with an iron bar. But what the court said here was, because Bailey had been a diabetic for years, and he knew the impact it had if he took insulin and failed to eat, and so therefore he was reckless in not eating, and his automatism was self-induced, i.e. he brought it on himself and therefore could not rely on it. So this self-induced automatism rule will prevent diabetics from deliberately putting themselves into an automatic state using their insulin in order to avoid liability for criminal offences. I'll end this video on a little summary of what we've seen. Automatism is quite straightforward. There is just this big overlap with insanity. So please remember, insanity is also known as insane automatism due to an internal cause, whereas automatism is also known as non-insane automatism, and it's due to an external cause. And for automatism, we just have two requirements: that the actions of the defendant must be completely involuntary and the cause must be external. Remember, we've got this issue with the diabetics, which seems daft, and we would critique that in an evaluation essay. But remember that the courts have developed this rule on self-induced automatism to get rid of the potential problem illustrated in Quick, whereby diabetics may potentially take insulin to put them in an automatic state so that then they can avoid liability for crimes.